morning. Please be seated. This is the time set for oral argument in Walker v. Sinakova, our cause number 1CA CV150174. Counsel, I know you're familiar with the processes here at the court. We've read the briefs, we've conferenced the case, and you can bear that in mind as you begin your presentations. You are being both audio and video recorded, and we'll have a chance to review the argument after today on YouTube, should you choose to do so. And if you would therefore let us know your name and that of the party you represent, it'll make the recording clearer. Each side has 20 minutes for argument, and you may reserve as much time for rebuttal as you wish, but you're responsible for watching your own clock and taking that time when you feel it's appropriate. With that, we can begin.
Sandra Burt for Sveta Sinakova, who is the appellant in this case. Good morning. The argument that I'm going to refer to the parties as mother and father, if that's okay with the court. So the appellant is obviously the mother. Our argument is that the trial court abused its discretion when it changed its previous orders and findings without affording mother due process of law. What happened was that in February of 2014, the court entered orders requiring the father to test for THC in his blood, finding that father's use of marijuana was not in the children's best interest. The father admitted to the court that his use of marijuana was not in the children's best interest during that same hearing. The court entered those orders. Father tested for several months, and then in July of 2014, he failed to test. Various issues went back and forth between counsel.
We pretty much know what the tests would have shown, right?
Well, in July of 2014, no, I don't think we know exactly what it would have shown because he didn't get the medical marijuana card. The date on the medical marijuana card is September. Well, I guess you're right, Your Honor. It probably would have shown that he was using, and that's why. But we can't, I can't speculate. So the test that he produced was not on the July 8 date when he was ordered to produce, when he was required to test. He had tested 3 days later at a facility in Alaska.
I guess the point is he's not really disputing that he's used marijuana.
That's correct.
So all of the testing seems somewhat collateral to the real issues here.
Well, the issue is that the court modified its order where it found that the children's best interests were served by father not using marijuana, and the court modified that order and just accepted the fact that father produced a medical marijuana card as prima facie evidence that father had obtained that card appropriately. He was an appropriate user of medical marijuana, and that the best interest of the children had therefore been accomplished because father had a medical marijuana card, even though he was going to use marijuana around the children. And this all happened without a hearing.
So one way to characterize that is that the court changed its order. Another way to characterize it is that the court didn't see sufficient grounds to change its order.
Well, under 411, is that what the court's referring to? Well, I would submit, Your Honor, that if there is a court order that requires a party to test and finds that the children's best interests are served by a particular parent not using marijuana around those children, and then the court unilaterally changes the order without the benefit of testimony, without the benefit of a hearing, the court basically saw that there was a medical marijuana card and said, oh, okay, the children's best interests are served.
So, counsel, is it your argument that the appropriate procedure would have been for father to file a motion to modify the existing order?
prior to obtaining the medical marijuana card. I think he should have filed the petition to modify. And then we would have had a hearing, and the court could have determined under 2811 whether father even met the 2811, whether father even met the definition of somebody who has a debilitating condition such that he needed to use medical marijuana.
But if in fact that hearing had taken place, was there any evidence that could have been presented by mother to show that these children were at risk?
I believe that, well, first I think father would have the burden. I think the court already found, Your Honor, that the children's best interests were served by father not using marijuana around the children. I think that's why we have the February 2014 order. So the court already had made that finding. And then at the hearing, father would have had the burden to show that he was an appropriate user of medical marijuana pursuant to 2811A2. And at that time, we would have gotten his medical records.
Well, why do you just assume that you would have gotten his medical records? Those are privileged.
Well, I think, first of all, I think he put the issue of whether he has a debilitating condition under 2811 in issue.
He never asserted anything. He, as far as I can tell, father simply used marijuana and then got a card.
Correct.
That doesn't waive the doctor-patient privilege.
But he stopped testing pursuant to court order because he had the card.
That still doesn't waive the privilege.
Well,
I don't understand the leap that seems to be made in the briefing from relevance to obtaining privileged information.
Well,
privileged information. The purpose of a privilege is to impede the obtaining of relevant information.
Except in this case, Your Honor, he is subverting or attempting to subvert a court order by saying I have a medical marijuana card. The presumption can be rebutted that that card was appropriately given pursuant to the AMMA. It can be.
The presumption can be rebutted if you've got the evidence, but sometimes privileges keep you from getting evidence.
Well, I would submit in this case that the privilege shouldn't keep the mother from getting the evidence. I think if
father... Is there any authority for that? I used to run into this in family court all the time. People wanted to get into these collateral issues, and so they wanted all the records, but the privilege exists.
Well, there is, and I believe it's under 403. I'm not sure. I don't recall the statute standing here right now, but there is permission. The court does allow the release of medical and mental health records all the time in legal decision making and parenting time disputes. It happens all the time. The court orders the HIPAA. The statute allows it because under 403, the court has to determine the best interests of the children. And if a party is making an argument...
So the best interest of the children in this case would have hinged on whether there was technical compliance with the AMMA?
Well, the court already found that the best interests of the children was not served by father using marijuana around the children.
What does the AMMA have to do with it?
Because father then said that, well, that order, it doesn't matter. I'm going to use marijuana around the children because I have a card under the AMMA.
That only tells you... I'm sorry.
Oh.
Go ahead. That only tells you if it's legal or not. It says nothing about the best interest of the children.
Well, that's the problem with the AMA. Well, I think...
Alcohol is legal, too.
Correct.
But the fact that you may use alcohol legally or illegally doesn't translate into a best interest
But
analysis.
This is the problem with the AMMA. This is the exact...
But that's a little beyond the scope of today's hearing.
Well, is it beyond the scope? I'm not sure.
I think Judge Kessler has a question for you.
Where did father say, and the court permit him to use medical marijuana around the children? I didn't see where father, when he submitted that he had gotten a medical marijuana card, where he said, I'm going to use this around the children, and the court said, that's okay with me.
Well, the court said he's not supposed to use it around the children, but he has the medical marijuana card, and the court got rid of the testing requirement, so father didn't have to test anymore without the benefit of a hearing.
Right, but father never came in and said, and by the way, I'm going to use medical marijuana around the kids, around the children, and the court never said he could do that.
All he said is, I'm going to test positive. So I'm not testing anymore, I'm going to test positive.
Of course he's going to test positive. because
Well-
he's got a medical marijuana card, so he's going to test positive.
But this is the bigger issue here, and this is the whole overlying issue with the AMMA. Under Dobson, when they tried to hand in, when the defendants tried to just say, here's our cards, we're fine, we can drive, and the court said, no, that isn't enough just saying, here's my card.
We're not here today for a policy forum on marijuana. I mean, we're trying to address whether there should have been an evidentiary hearing in your client's case. And
Okay.
there's an element that you've left out of the discussion, which is the work of the parenting coordinator.
The parties went to the parenting coordinator and mother presented the issue to the parenting coordinator. She said that she was not going to address the father's having a medical marijuana card. Mother went to her before mother filed the petition with the court. So she asked her to address the issue. She said that she wasn't going to address the issue. Then mother presented the issue to the court so the court could address the issue.
But she didn't seek the mediation that the court had ordered.
The PC is the mediator, essentially. I mean, that's who, there isn't when you have a PC, it's just how it's done in family law court. When you have a PC, that's who you go to
I'm
try
not
and work.
unfamiliar with the process, and the question of whether there should be a PC in this case might be resolved differently today than 2
Correct.
weeks ago. But the fact remains that there was a process contemplated under the order that did not occur.
But if there's an exigent circumstance, in this case, we would argue that there was an exigent circumstance, then mother was appropriately raised the issue with the trial court before she raised it with the PC. It wasn't going to go anywhere with the PC. She wasn't going to deal with it. That's the party they would have gone to, and then mother presented the issue to the court. If mother was supposed to sit on her hands and wait 2 months to get into, let's say, court conciliation services for mediation, while father is knowingly violating a court order that the court entered in the best interests of the children. That's what the court said. I'm entering this for the best interests of the children.
Counsel, there is a bootstrapping aspect to this argument, and that is, as I read the PC's report, mother did not present any specific evidence that father was using marijuana in front of the children or it was affecting his ability to parent the children. And then your argument essentially is, why should I have to it would be futile for me to try to mediate this with the PC because the PC isn't, in essence, it's not going to go anywhere. It seems to me there is, and father makes this argument, there is an aspect of bootstrapping. If one party doesn't want to present specific evidence to the PC or doesn't have specific evidence to present to a mediator, and then goes to court and doesn't have specific evidence of him using marijuana again with the children there, or it's affecting his ability to parent the children, how can you say, well, mediation failed because the PC wouldn't address it? The PC wouldn't address it because she said, I don't have any specific, mother will not give me any specific evidence. And then you say, well, it's all futile, so I'll go to the court. And then in your petition, well, as I read your petition, all the petition did was say, listen, back when you originally, all these earlier PCs and doctors said there's a concern about his using marijuana, and so therefore we have a right to, that's the exigent circumstance. And that's not really specific evidence that he's using marijuana in front of the children or with the children there, or it's affecting his ability.
Well, the problem is that we had the history of father's issue since 2010, and then we have the court order saying this is contrary to the best interests of the children. So the court had already made that finding based on the history. So mother was presenting to the court, hey, you've made this finding based on these 4 years of history, and here we are again, he is using. So the court already found that it was contrary to the children's best interest. The use was contrary to their best interest.
It's use that in essence is legal in Arizona, and there's no evidence that he's using it. There's no specific evidence presented that he's using it with the children there, or that he's using it as use of it under the medical marijuana card is affecting his ability to parent. So why should the court have an evidentiary hearing to revisit this until that evidence is presented?
Well, I would argue that the court has already found that the fact of using is the issue.
I don't think that's what Judge Kessler's asking. I think that's an assumption in the question. The question is, okay, the court's made this finding as a general proposition. If you're asking for a change in the order, and it is your client asking for a change in the order, don't you need to have specific evidence to justify the change?
No, we're not asking for a change. We were telling the court that the order you entered in the children's best interest is not being followed.
To what effect?
But-
I mean, that sounds just sort of like
But the
griping. You wanted a remedy.
But see, here's the problem, that we have a man, okay, we have to look at the history. We have this father who has had this ongoing serious issue with abuse of marijuana. So that's the history. This has been going on since 2010. And there were time and again, I can stop, he can't stop. The children come home with drugs.
Okay. Did you want a remedy or not?
Did we want a remedy?
Yes.
Yes.
And what was the remedy?
And the remedy that we wanted is for father to stop using marijuana around the children, to find out if he was even appropriately.
Wanted no adjustment in legal decision-making, no adjustment in
No, we
parenting
did.
time?
We
Okay.
did.
Okay. So you're asking then for a modification.
Correct.
Okay. We've established that. Now, if you're asking for a modification within the time period prescribed by 411, you need to come up with a showing demonstrating the exigency. Here, the only showing is that he may be using marijuana,
Well,
which was already a factual scenario that had been processed into the prior order.
But that's the point. It's already a scenario that was processed in an order that said he shouldn't, and then he was. So
Switch gears for a second,
Okay.
though, because time is running out, and I have a feeling that we're going to hear something about the recent motion to dismiss in about 4 minutes. So do you want to say anything about that?
well, I would argue, first of all, that there have not been any court orders that have addressed this issue. So they pointed to a recommendation that was adopted by the court that was issued by the parenting coordinator, and the 4 items in the recommendation that was adopted by the court addressed school issues, taking the children to counseling issues, nothing regarding father's use and contravention of the court order. She had discussed use issues in her report, but it's the recommendations that are adopted by the court. It isn't every statement that's made. It's specifically the recommendations. So that did not address the issue. And when one of the children tested positive for THC, 35 nanograms per milliliter, the 7-year-old, mother filed an emergency petition, and Judge Cooper said that DCS and the parenting coordinator were dealing with the issue, and then they ordered DCS to release the records to the parenting coordinator. I'm sorry. Okay. They ordered to release the records to the parenting coordinator so she could review them. Well, that happened, several months ago, and we don't have any type of I guess there's 5,000 pages. I mean, it's pretty huge. So we don't have any recommendation from the PC. So there wasn't an order by the court that addressed parenting time or even really addressed all of the issues mother presented in her petition. And since they presented everything to the court, I would tell in their motion to dismiss, I would tell the court that there is an email from DCS that father's level of THC was 3,000 nanograms per milliliter, and the level of THC that the various states, Oregon, Washington, Colorado, are considering to use to determine if somebody is impaired when they're driving is 5 nanograms per milliliter. So we have father who is at 3,000 and the child who is at 35.
So what your argument is that there is no final court order addressing whether right now, the current order is that father can use medical marijuana as long as it doesn't impair his ability to parent, and that he keeps the court apprised of the renewals of his medical marijuana card.
Yes.
And so you're
well, it's
arguing-
not, I mean, I think the first part, Your Honor, is not exactly what the order said. The order was just that he didn't have to test and he had to keep
He didn't have to test, and he didn't have to,
apprised.
and he couldn't
Use around the children.
around the children.
And now that
And so you're saying that order's the order in place. You haven't had your evidentiary hearing on your request for change in parenting time and
Right.
legal decision making, and therefore it's not moot.
Correct.
Is that your argument?
Yes, that is my
Okay.
argument,
Thank
Your
you.
Honor. Thank you.
Okay, thank you.
Okay, I guess I'll reserve my 40 seconds. Okay, thank you.
May it please the court, my name is Keith Berkshire, attorney for the appellee, Judd Walker. While we filed the motion to dismiss because of mootness, I think really what this case relates to is the cases like Siegert and Dorman. I mean, this case, I think when I added up the number of the index of record, I think we were in the mid 400s at the time we filed the appeal, and I think we're pushing 500 now. There was actually a PC report that was issued after I filed my motion to dismiss on Friday. A new one was issued that actually deals with this also as well. But the situation here with what the court did is actually somewhat ironic that mother is the one complaining about this. Because honestly, if anybody should be complaining about this, it should be father.
Wait, on the motion to dismiss, since you raised
Okay.
that, are you saying the motion, we should consider the motion to dismiss, or are you withdrawing?
No, I think you should, because the court right now is still in the process of dealing with father's medical marijuana use. Not only is the family court dealing with it, DCS is dealing with it, the parenting coordinator is dealing
Well, it
with
may
it.
very well be that no matter what we rule on the motion to dismiss, there will be proceedings between these parties.
And I think,
But for us to bow out because of that would just be to suggest that there's no appellate remedy in post-decree matters because they keep happening, and that's not the law.
no, absolutely. I think it's just this case is the epitome of why this court in Siegert and Dorman said that the trial court should be given wide discretion when to hold hearings. In this case is the absolute, I mean, how many cases have, after a 5-year period, have 500 pleadings? I mean, this is that top 1% case as far as the level of conflict, the amount of court involvement, and frankly, the level that the trial court judge knows about the case. I mean, at the time that before Judge Cooper took over, I mean, Judge Edelman had dealt with in excess of 200 to 300 pleadings and filings on this case. This isn't somebody that's unfamiliar with the case, and this is why they have that function. It's why 411 is specifically allowed, so they can decide that they don't have to hold a hearing on every single thing. And as Judge Swan, you asked, their relief requested in their petition was they were asking for a lot. They were asking for supervised visitation, which has its own tremendously high standard under this court's case in Hart, they were also asking for it in under a year. So even if it was beyond the year, they were asking for supervised visitation, what this court can kick out on its own, which the trial court could kick out on its own because of the standard they have to go under 25411 or 25408A, where it's essentially the same standard for if you file for under a year or ask for supervised visitation, that the seriously endanger the child's welfare.
Your argument, we're getting to the merits, is that they didn't make that showing.
Our argument is very simple. They didn't make the showing. What the court did in its ruling was just acknowledge a fact that drug testing does nothing. It's the same as saying that alcohol enzyme testing. What this court did was the same as when trial courts do alcohol enzyme testing, and they still have an order that says you can't drink around the kids. Well, if the enzyme's in your body for 5 days and you have 1 day of parenting time, the test does nothing. It doesn't show that you drank around your kids. The order stayed in place despite the medical marijuana card, and the fact that my client is the one that could go in and petition to remove the restriction I mean, right now there's a restriction, I could say somewhat in violation of a statute, but he's never asked for a hearing on it, so it's not. But there's a restriction on his parenting time that doesn't allow him to do marijuana during his parenting time.
The AMMA contains a right to smoke marijuana around your children.
I don't think
Any more than the 21st Amendment allows you to get abusively drunk around your children.
I would agree. But I think the restriction in the current order that you cannot during your parenting time, this would include, at night, not near your children in a medicinal use, the same as popping a Vicodin for your back before you go to bed, when it's not impairing your parenting time. That is more restrictive than I think the statute would allow, if he chose to contest it.
Well, he hasn't contested it.
And that's the point.
So really, the issue before us is not whether father's unhappy with the revised order. It's whether mother made her case to get a change in parenting time and legal decision-making on an expedited basis because of exigent circumstances.
I agree.
If she didn't make that case, and the court didn't have to hold an evidentiary hearing, if she did make that case, then the court abused its discretion in not granting an evidentiary hearing, not whether father is happy with the order or not.
Absolutely. We think the AMMA is essentially irrelevant in this situation because of what the court did. And I think the standard that this court said in Siegert, which is that in that case, this court said, we're able to conclude that no reasonable judge would have denied the request for a hearing. And I think that's the situation, is just, would every judge have granted a hearing in this case? And that's the discretion that the trial judge was given here, is that this is the enigma that every other judge in the same circumstances would have been given a hearing. That's not the case here. They didn't actually make an allegation about the children. They made an allegation that he didn't test. And over in appellant's argument and appellant's briefs, they argue that there's this best interest finding that dad using drugs around the children was a specific finding. There was a specific finding that he's not to do that. If we really look at what they're quoting a generic provision out of a drug testing part of the minute entry. The one that says if it's diluted or not, we assume you're positive, and positive is bad. This is the section. There wasn't some other finding by this court, absent the generic drug testing language, that father shall not, it's been bad in the past. There's nothing like that in the minute entry. It's the standard drug testing minute entry, part of that February minute entry. In reality, this is just it's just a procedural process. The court, the reality is if they had enough, they could have filed this, they could have had a new hearing on this, they could have refiled this case. They could have been done with this before we were even here today. But the court found that given this situation, the mediation requirement was there for a purpose. Whether you like it or not, the court ordered them to go to mediation. They didn't, and they also didn't allege enough to meet the situation under 25-411. And I think it's especially important, as I said before, that it would be one thing even if it was after a year. The court still could have kept this out even if it was after a year. But the heightened burden in under a year, and the heightened burden to go to sole custody, and the heightened burden to ask for supervised visitation, that's what we have to look at here. And all they've alleged is he didn't test, he didn't test, he didn't test. I don't think that's a question of fact. He didn't test. He then got a card. But he has never petitioned to use it around the children. And their argument throughout appellant's argument today that he's using around the children, we have no proof. They have nothing. Every PC report where the kids have been interviewed, the kids interviewed by their therapists, not one report has ever said he's used it around the children. If they had that, that's potentially a change, because that's a violation of the order and the spirit of the order where he's not to do it around them.
Well, it certainly sounds atmospherically like some of the evidence coming out these days could be problematic for your client. But the inquiry we're faced with is whether the trial court abused its discretion at the time. And
not to get into what's going on these days too much, but according to the last PC report, the drug test that appellant talks about, no one's ever found. And the PC report, the latest one that came out on Friday, says we've never seen this test. That's why we're not addressing it, despite mother keep talking about a level. We've never seen it. No one's ever produced it. And if it's produced, the PC will deal with it. The PC also found that there was no evidence that father is the one that this occurred around father.
Well, there was an allegation made that DCS has now released 5,000 pages of records. Is that in response to to what happened after this order was entered?
I mean, it's also only in camera for Annette Burns, so I don't think anybody knows. I think it's unfortunately up to Annette at this point. But again, back to the issue here, everything that's happened after this case is, even though it shouldn't really be considered for this court unless you want to deal on mootness, it really is just more fodder for the fact that this is why gatekeeping exists. It's the fact that after hundreds and hundreds of pleadings, the trial courts have to have this discretion. I mean, how many petitions, how many PC reports, if they didn't and required a hearing on every single case? I mean, Maricopa County is bad enough for hearings and amounts of time in hearings. I mean, if they required it on every single one, it would be that much worse.
So we got into the post appealed from order proceeding simply because I think it was a segue from your argument that there was another alternative open to her. She didn't make her burden of proof. Mother did not meet her burden of proof on her petition. And I think, as you argued in your brief, the argument would be she should have come forward with other evidence to show exigent circumstances, or waited until the year passed to show exigent circumstances or the need for a change. And that's, in essence, what's happening now, is she's trying to do that.
It is. I mean, the year passed before they filed their docketing statement. I mean, it's long passed since then. And the issue in this is the generic, he's using marijuana, it's bad. It's the same as the Supreme Court said in Pridgeon, which is you can't just make claims they're a bad parent. This is in the kid's best interest. You actually have to come up with facts under each of the 25403A factors. That's not what happened here. There's nothing that they point to that on Tuesday, October 5th, Dad was so wasted he was talking to the pink elephant on the wall, around the kids, or showed up at the kids' school wearing no pants. I mean, those are facts that would make a difference. Those are facts, not he didn't test. So the actual allegations of how this impacts the kid, and this is exactly why these series of cases, and Pridgeon and Dorman and Siegert rely on, that you have to actually allege an occurrence, which is what we think is missing here. And again, what the court did, they never actually modified anything. When they specifically kept that restriction, I think that's the biggest part of this.
Did modify the fact about
I think they acknowledged a reality more than a modification. I think the way Judge Swan put it earlier, is it a modification? Well, technically, did it change words in the order? Yeah. But from the reality is, we know he's going to test positive, so why are we doing it? I would point out he's actually still testing. So it's the issue of what does a positive test mean? It's the same as the alcohol. You can prohibit, and courts do it all the time. We prohibit alcohol during your parenting time. Is there any effective way to test that? Short of a breathalyzer at the start and end of parenting time for alcohol, you can't do it. But there's no way to do that for marijuana at this point. So it's more of just an acknowledgement that he is going to test positive. With that, unless you have any other questions.
Just a few brief comments, unless the court has something they want to ask me. No? The trial court already found that the best
Your clock's not running. We'll
okay.
Go ahead.
Okay. Thank you. The trial court already found that it was not in the children's best interest to use marijuana, and mother presented the issue to the court that this is what was occurring again. Based on the history of this case, the court should have set a hearing. I think violating a court order that was entered in the best interest of the children demonstrates the exigent circumstances under 411. And under 411A, the court after a 6-month period had elapsed, and it had more than elapsed when mother filed, the court could have at least addressed the legal decision-making of the children, because that 411A provides that if someone is not following the joint legal decision-making order, you can file before the end of the year.
Was there some legal decision in controversy, or
Well,
was that just sort of a available remedy that has some theoretical impact?
Well, there's always something in controversy. I mean, the case has been going on a long time, so yes, there's always something in controversy.
Okay. Thank you. Thanks to both sides for your arguments. The matter is now under advisement. We will issue a written ruling in due course and stand in recess to allow the next case to set up. Thanks.